Well, some familiar and infamous Wall Street names are making headlines again. Bernie Madoff, Lehman Brothers. Well, victims of Madoff's Ponzi scheme are still looking for ways to reclaim money they say they're owed. And as for Lehman, it's facing fresh court battles with some of the world's largest banks. With us now is one of the nation's foremost bankruptcy attorneys, Harvey Miller. Just last week, the Financial Times, Harvey, named you the most innovative lawyer in the U.S. You're also a partner at Weil Gotshal Manges, and you represent Lehman Brothers in its filing, and we're going to get to Lehman in just a moment. But you told the Wall Street Journal we're going to talk about Madoff. You told the Wall Street Journal Irving Picard is, quote, pushing the envelope a bit in what he's doing, and that's what litigators do. Now, we're referencing, of course, the flurry of lawsuits that have recently been filed as Picard faces a Saturday deadline. He has 2 years to sort of file these lawsuits in this particular case, which means that this coming Saturday is a big deadline, and we have seen tons of lawsuits now filed. What is your take on that?
Well, excuse me. Because of the 2-year statute, Mr. Picard has to make sure he's collecting and preserving all the assets in the estate. He and his attorneys have come up with a theory that there is a lot of liability out there on the part of financial institutions who have done work with Madoff. It's somewhat novel theories, I think, that he is proposing.
He's definitely in uncharted territory from a purely legal perspective, right? And how is he in uncharted territory? Is this in terms of the sums, and the amounts that he's looking to recover?
Excuse me, I'm sorry.
That's okay. Maybe we can get a glass of water.
He's in this gray area. What are the fiduciary duties of a financial institution which acts either as a conduit for clearances of trades, money, etc., as compared to a financial institution that is servicing feeders? There are different levels of responsibility, and the law certainly is not clear that a financial institution has fiduciary duties to investigate or to discover fraud and then go out and report it. I mean, there's a difference between if you saw somebody being attacked on the street, you might have an obligation to report it, call the police or something. But if you're a bank and money is just passing through,
right? Should you be charged with the crime of actually committing that robbery itself? What do you estimate will be his recoveries? How successful do you think Irving Picard will be in this?
Well, that's a hard question because most of the complaints are under seal, so I don't know what they say. He did settle one case for $500 million against UBP, I think it was.
Yes, this is a Swiss private bank,
yes.
Which is interesting. This is the first case that he actually settled.
Right. And we don't know what he was going to accuse that bank of because they never filed a complaint. They settled it before they filed a complaint. And my guess is the settlement agreement is going to have some confidentiality provisions in it. But in this world that we live in, with emails and all of the technology, sometimes you find in files some very damaging things which give rise to the potential of liability. So the question here is how deeply involved are these financial institutions with the Madoff empire? And remember, this thing went on for 15 years. That's a long time. I could ask the question, where was the SEC during this period? And now you're going beyond the SEC and saying JPM and HSBC and Deutsche Bank had a duty, maybe a duty of inquiry and a duty of disclosure. Now,
you said it's difficult to figure out exactly what the potential is in terms of recoveries, and that he's really in uncharted territory in the types of lawsuits he's actually filed. Let's talk about what the risks are for him in this situation. I thought it was interesting. We were talking about the Wall Street Journal blog in which you were quoted. He could actually be sued, Irving Picard, in this situation.
Sure. Undoubtedly, there's no question that a trustee like Mr. Picard is a fiduciary. His responsibility is to preserve and enhance the value of the assets that he has. A lawsuit is an asset. And from his perspective, if he did not pursue what he thought was a viable lawsuit, some creditor, some party in interest could claim that he did not preserve the value of that asset.
So while some may criticize the number of lawsuits he's actually filed, it is sort of his obligation to do so.
If he thinks they're viable causes of action.
Okay.
That there's a possibility of recovery. Now, he did make a settlement a week ago with
UBP, Union Bancaire Privé.
And that was $500 million on a claim of $1 billion. 50% is not bad in litigation.
I can imagine he's under a great deal of pressure from the investors in Madoff's fund to actually come with a settlement quickly. But let's turn to Lehman Brothers now. I know it may seem like a distant memory for many of us, but those who are directly impacted are certainly, it's still sort of early on in the process. And now there are still hundreds of billion dollars owed to the creditors. Lehman's lawyers suing Barclays, I think, for $11 billion. That would be you. They're suing JP Morgan, $8.6 billion. But just in the last week, right, JP Morgan is now countersuing, which is sort of an interesting development, at least from an outsider's perspective. Give us a little bit of an update on where that process stands.
Well, the lawsuit against JP Morgan was initiated, I'd say, about 5 months ago. And that lawsuit basically takes the position that JP Morgan extracted assets and value and cash by making various demands on Lehman during the last 10 days before it went into bankruptcy. And that was improper. Guarantees were allegedly extracted. $15 billion of cash collateral was demanded, which may have accelerated or precipitated the run on the bank, so to speak. JP Morgan denies all those allegations, and then, as in any lawsuit, has a right to assert a counterclaim. And they also had a statute of limitation or a timing problem. December 1st was the last day they could do that. JP Morgan has filed a counterclaim saying that essentially it was defrauded by Barclays and Lehman. That in connection with the Barclays sale, Lehman and Barclays cherry-picked securities so that they left JP Morgan with the most illiquid, bad securities. And as a consequence, JP Morgan was allegedly holding the bag for something like $25 billion of securities that weren't worth $25 billion.
When do you expect Lehman Brothers, when do you expect to be able to close the chapter? Or for us as the American public, when do we close the chapter on sort of the mortgage meltdown? I mean, it didn't start with Lehman necessarily, but that certainly happened at the beginning of the process.
Let me speak about Lehman, okay? Lehman will propose a Chapter 11 plan during the first part of 2011. That will be just a step to close the administration of the bankruptcy case. The litigation will go on beyond that. The plan will probably have in it what is called a litigation trust, in which those litigations will be transferred there. To litigate those cases, if they're fully litigated,
yep,
maybe 3 years.
All right. Thank you so much, Harvey, for joining us.